So what are some themes of the Roberts Court's free speech jurisprudence over the now, actually be 20 years this fall that Chief Justice Roberts has been Chief Justice since 2005. One, and of course this is familiar in other areas of constitutional law as well, is that partly by virtue of the turn toward originalist methods of constitutional interpretation, the court spends a lot of time looking to the history and tradition of the Constitution with regard to how to interpret the Constitution. And those categorical exceptions that I mentioned earlier, like true threats, incitement, obscenity, crime facilitating speech, those have traditionally been regarded as, again, exclusions from First Amendment protection. But the court has very insistently, in a few cases the last few years, insisted that no more creation of categorical exemptions. So basically, the list of categorical exemptions from First Amendment protection, that list is now closed. And a couple cases in which this was very clear was a case from 14 years ago, a California statute that regulated the sale of violent video games to minors, to people under 18. The court struck that down, saying that violent speech is not a new category that is outside the protection of the First Amendment, and that in that case, California's restriction on the sale of violent video games to minors without an adult's permission, that kind of restriction violated the First Amendment. And a case a few years ago, Mattal versus Tam, which involved an Asian American band that sought to trademark the name Slants as the name of the band, which of course is an anti-Asian slur, but they themselves were Asian. They wanted the name of the band to be that, somewhat ironically. But the trademark law of the United States has a provision in it that prohibits the trademarking of terms and names that are disparaging, including on racial grounds, and the Supreme Court struck that down and said that hate speech or racially insensitive speech like that, that too is not going to be a new category outside the protection of the First Amendment. And so in that case, once again, the court insisted we're not expanding the list of the categorical exceptions to the First Amendment. There is no hate speech exception to the First Amendment, which often even last few days has been sort of bandied about as an exception. But I'm telling you right now, the doctrine on this is as clear as could be, and Mattal versus Tam in 2017 reiterated it, that there is no hate speech exception to First Amendment protection. Another theme over the last 20 years is that the court is extremely free speech protective. We're probably living in some ways in the high water era of free speech protectionism in the history of the US Supreme Court, and really in some ways of almost any jurisdiction in the world. The US Supreme Court is extremely free speech protective right now, so that if you bring a claim in front of if the court takes a case and it's bringing a free speech claim, those free speech claims almost always prevail, outside of a few very, I might even say, idiosyncratic exceptions. A case a decade ago that regulated judicial candidates in state judicial elections and their soliciting of contributions. The court said that restriction was okay. National security concerns, I'll talk a little bit about the TikTok case at the end, and then restrictions this last summer in a case involving age gating of access to pornographic websites. The court upheld that. But outside of this and a few other random examples, every free speech claim for decades now, at least since John Roberts became Chief Justice, has been successful. And so we'll talk a little bit more about that. But again, just as an overarching theme, this is a very free speech protective era in American jurisprudence.